welcome back to Overruled, the lovely little podcast you never knew you needed in your life. Here, we talk about all the hot takes in law. We're going to talk about all of the things that you need to know so that you are armed in these legal streets, all right? I'm your host, Jay, and listen, if you're just joining us, welcome aboard. If you've been listening since episode 1, my God, thank you for being consistent like I'm being consistent with y'all. Okay, so without any further ado, we are going to jump straight into our first segment, the issues on the docket, because there is so much going on, and I feel like I am talking to you guys about the same topics, but it's just like, oh my goodness, there's so much happening, y'all, that like we have to talk about it. We can't waste time on it. We need to talk about it now. So let's jump right into it. All right, y'all. Let's talk receipts, rights, and the legal smoke that's not getting nearly enough coverage. This is Issues on the Docket, the segment where we put the hottest messes in law and policy on trial. Because if the system's moving in silence like the G in lasagna, shout out to Lil Wayne if you know that song reference, we're here to turn the volume all the way up. Shoot, that's another reference and another think about too. That's another song. Listen, we love music here at the Overruled podcast. But anyway, today we're digging into how Congress is finally clocking AI deepfakes as a threat, how Halle is pulling back the curtain on abuse and motherhood in the public eye, and how HIPAA is finally getting the glow up it needed, like 3 data breaches ago. Y'all, these aren't just headlines. They're hard truths wrapped in legal armor. So, you've been warned. Buckle up, because court is officially in session. Our first story for this week is going to surround the Take It Down Act, which has been a bipartisan move against digital exploitation. Now, with some great reporting that has come from the Washington Post, I want to give you a little context first, and then we're going to dive a little bit deeper. So, imagine waking up to find a hyper-realistic, AI-generated explicit image of yourself going, girl, are y'all kidding? Get the out of here. Ice cream man. It like 8 of them? Get out. Get out. Go away. Shit. Oh my God. Why the ice cream man? Girl, I don't want your questionable ice cream. Okay. Imagine waking up to find a hyper-realistic, AI-generated explicit image of yourself going viral. One you never consented to, never posed for, and never even knew existed. That's not sci-fi, y'all. That's 2025 reality. And it's disproportionately targeting women, minors, and marginalized communities. I'm sure the audience takes a collective sigh of, oh, I'm not surprised here. Now, here, specifically at this crossroads, is where the Take It Down Act steps in. A rare bipartisan moment in Congress led by Senators Amy Klobuchar and Ted Cruz, which, whoa, and backed by none other than Melania Trump herself. Wow, who's made online safety her crusade. I find irony in that, but you know what? I'm gonna let her cook because I have more to tell you all. The act criminalizes the distribution of non-consensual intimate imagery, or NCII, including deepfakes, which are becoming eerily indistinguishable from real content, and forces platforms to remove flagged content within 48 hours of victim notification. Offenders face up to 2 years in prison with enhanced penalties if minors are involved, which, yeah, you damn sure, they need to be going away for much longer than 2 years if some children are involved, because we don't play that around here at the Overruled podcast. And you know what? It doesn't matter if the image was digitally altered or AI generated. If it depicts you and it's intimate, it's protected. Now, the legislation isn't without its critics. Civil liberties groups like the ACLU are raising red flags about vague language and the potential for First Amendment overreach. One of the prevailing themes we've talked about a lot over the last few episodes, the First Amendment, right? So, how do we draw the line between harmful exploitation and satirical or artistic expression? I'm sure all of you have seen AI generated GIFs, memes. They're out there and they are funny, but what happens when they're crossing the line into depicting intimate scenes, depicting sexual content of any sort, and it's not with your permission? Can tech platforms even enforce this consistently at scale? These are questions that really do need answers with this Take It Down Act. This law is a much needed first step in modernizing our legal protections against tech-enabled abuse. But it also opens the door to new debates around privacy, consent, and speech in the digital age. The real question isn't whether the law should exist, because it should. It's whether it can be enforced without becoming another blunt instrument in a space that desperately needs nuance. More to come on this story. Guaranteed, we will update you here on this one. All right, and just as a simple trigger warning on this next story, because it does involve alleged domestic assault, we're going to talk about Halle Bailey's custody battle, the legal protections, celebrity, and really the general struggle as a celebrity to be believed in these types of situations. There's been some great reporting that's come out through People Magazine, Entertainment Weekly, CNN. And, this story has both personal and public weight to it. Halle Bailey, we know her, our Little Mermaid, our Ariel, our Black Ariel, actress, singer, and new mom, is fighting for sole custody of her 1-year-old son, Halo, after filing court documents alleging physical, emotional, and financial abuse by ex-partner and YouTuber turned rapper DDG, aka Daryl. I'm just gonna call him Daryl Granberry. Now, when we talk about these filings, it's important to note the different types of abuse that were mentioned. The abuse isn't just emotional, it's physical. It's also financial in nature. Bailey recounts a January altercation where DDG allegedly slammed her face into a steering wheel, chipping her tooth. She also claims he confiscated her phone, destroyed property, and used his massive online following to harass and intimidate her digitally, essentially turning fandom into a weapon. And another great example of this type of internet behavior that is unacceptable, let's talk about the very toxic stan culture that exists with certain artists, particularly with any sort of Nicki Minaj, like Stan. They have been in a place over the years where they have been able to dox people, allege that they're going to harm them in some form of fashion, show up. Bailey has been granted a temporary restraining order, and a formal hearing is set for June. But the case has reignited a larger conversation. Even high-profile women with resources and platforms, notoriety, they face uphill battles in custody courts, especially when abuse allegations intersect with public image, money, and influence. This story is very unfortunate And it really isn't even most important because it is involving a celebrity. This is not just a celebrity custody dispute that you would see in the tabloids. It's a high visibility case highlighting the gaps in legal protection for survivors, particularly those navigating co-parenting with their alleged abuser. The fact that someone as visible as Halle still has to fight for her safety and credibility should tell us everything we need to know about how under-resourced and disbelieved most survivors really are. And stop for a second. Really think about that. How many survivors do you know or you have heard of that people don't believe because they'd rather believe the male perspective and they'd rather fall into the misogyny of it all? The legal system needs to do better for Halle, for Halo, and for the countless survivors listening and just existing in the world whose stories never make headlines. And for our final story in this segment, we're going to talk about HIPAA. The federal push to modernize medical privacy in a very hacker-dense world. With reporting consulted from Reuters, let's talk about HIPAA. And don't worry, I'll remind you of what that is. Data breaches aren't just annoying. In healthcare, they can be life-threatening. In 2023 alone, over 133 million patient records were compromised in ransomware attacks. You didn't hear me wrong there. That's not a glitch. That is a full-blown security crisis. Now, the Department of Health and Human Services, HHS, is finally taking steps to drag HIPAA into the 21st century. The proposed update to the HIPAA security rule, the first real overhaul in decades, mind you, includes mandatory encryption, multi-factor authentication, better known as MFA, and routine third-party security audits. You know, all those things that in your apps you love to use have been instituted to give you an additional layer of security and safety from having your account compromised. Now, the goal? Build a nationwide security baseline that actually reflects modern digital threats, not those early 2000s tech threats that are so obsolete. The update also calls for real-time breach notifications, staff training mandates, and tougher penalties for non-compliance, all in response to the skyrocketing sophistication of cyber attacks targeting hospitals, clinics, and digital health platforms. So, of course, you know you're going to hear me say this because it's true. This is not just a singular issue affecting one industry, okay? It's not solely focused on medical records or IT in general. It is a matter of general patient dignity, safety, and trust.
All right.
From abortion seekers in restricted states to trans patients accessing gender-affirming care. The stakes around data privacy in healthcare are increasingly higher and higher as we evolve in the modern era. These updates signal progress, but enforcement, funding, and tech equity across smaller providers will make or break its impact. Because let's face it, guys, in this digital age, protecting our bodies starts with protecting our data, which would you really have thought that 10 years ago?
Nope.
I can guarantee not. Maybe some of you did. And that's the docket, folks. Whether it is digital exploitation, intimate partner abuse, or medical privacy, these things all remind us that rights mean nothing if they aren't protected where it counts when it matters most. These aren't isolated incidents either. They're signals. Signals that the law is still playing catch up in a world that's moving fast, reckless, and breaking damn near everything in the process. And if we're not watching the rule book get rewritten in real time, we're gonna wake up one day and find ourselves on the wrong side of things. So stay alert, stay loud, and don't let anyone tell you these legal fights do not affect you. Because if the law can fail them, it can sure as hell fail us. Let's keep it moving. All right, we're gonna take a quick break, and then when we return, we'll jump right into precedent pending. You ever hear about a case and think, wait, they're doing what? Based on which law? From when? Yeah, that part. We're heading into a situation, folks, that's got 18th century energy and 21st century consequences, where immigration, executive power, and due process are all colliding like it's a 3-car legal pileup. Welcome to Precedent Pending, part of the show where the courtroom drama isn't just real. It's rewriting the playbook and has major implications. Today's case, the President of the United States, a group of Venezuelan immigrants, and a law that predates electricity. Literally. So yeah, buckle up. Today we're diving into a legal showdown that's part history lesson, part high-stakes immigration drama, and believe it or not, it centers on a law from 1798. Yeah, you heard me right. WMM v. Trump represents a group of Venezuelan immigrants that are challenging President Trump's use of the Alien Enemies Act, which is a law that is so old, it was signed by John Adams. And this law that is being used now in 2025 is being molded to allow President Trump to deport these Venezuelan immigrants without proper notice or due process. It's as if someone dusted off a colonial era rulebook and started swinging it around in modern day America to see what exactly it'll hit. Now, if your eyebrows just shot up a bit, you're not alone. Using an 18th century wartime law to kick out immigrants in 2025 sounds like something out of a political time machine, and it also doesn't sound right. So, how did we get here? Let's set the stage with a quick journey back in time. And don't worry, there's no hot tub time machine or DeLorean here that is required. But we're gonna go back to understand what the Alien Enemies Act actually is, why it exists, and why is it so controversial. The Alien Enemies Act, AEA, was born in 1798. Born, LOL. Anyway, amid fears of a war with France. It was part of the infamous Alien and Sedition Acts, which were basically the Federalists' way of saying, we're scared of foreigners and critics. John Adams' administration wasn't exactly chill about the concept of dissent. So here's the gist. The AEA gives the president power during war or invasion to apprehend, restrain, secure, and remove any non-citizens from a hostile nation. Now, in plain English, for everybody else in the room, if we're at war with country X, the president can detain or deport folks from country X living in the United States without a trial, a hearing, or anything like that, just because of their nationality. Due process? Not really a thing under this law. Now, historically speaking, The act has been like that one tool in the shed you really only use in an emergency. And even then, maybe you shouldn't. It's a bit faulty, if you will. It's been officially invoked only 3 times in over 200 years during the War of 1812, World War I, and World War II. And it has a pretty dark legacy, honestly. In World War I and World War II, the AEA was used to justify sweeping actions against immigrants from enemy nations: Germans, Austrians, Japanese, Italians, you name it, often solely because of their ancestry alone. The Japanese American internment during World War II is the most notorious example of this. Thousands of Japanese immigrants, even those that were of Japanese descent and US citizens, were locked up in camps. That period of time was so shameful that the US later formally apologized for it. In short, the AEA is a wartime relic with a lot of baggage. It was intended for national survival, but it's always been ripe for abuse, misuse, casting aside fundamental rights in the name of security. You get where I'm going here, right? Why is it controversial, you may ask? Well, imagine a law that lets a president pick a group of people based on nationality and essentially say, you have no right to stay and no right to a hearing. I can kick you out because you're from that country. This is the Alien Enemies Act in a nutshell. And it screams and reeks of due process violations to a lot of people. Even in wartime, it was criticized for sweeping up innocents. And by innocents, I mean innocent people. And crucially, the AEA is the only one of those 1798 alien and sedition laws still on the books. And I'm not talking about cite me, don't fight me. We're talking about real life craziness still existing over 200 years later. This one, for some reason, stuck around, largely ignored, like a loaded cannon in the attic. No president dared fire that cannon in peacetime. Until now. Fast forward to 2025. The United States is not in a declared war with Venezuela. Last we checked, we haven't declared war on anyone since World War II. But hey, anyway, keep that nugget in your back pocket. President Trump, however, decided to invoke the Alien Enemies Act anyway. The first time ever during peacetime. Mind you, one of the key components of the AEA being applied is during times of conflict, war. And remember, we're not in a war. I just want to make sure y'all are keeping up and you're picking up what I'm putting down, okay? So how did this AEA get enacted in the first place by President Trump? Well, he did what he likes to do a lot. He just issued a proclamation in March of 2025 claiming that a Venezuelan criminal gang called Tren de Aragua was essentially invading the US. This gang, he alleged, it was not just a crime problem, but a foreign threat, even branding them a foreign terrorist organization. And under that pretext, Trump said he had special wartime powers to skip the usual court process and deport anyone his administration tagged as a gang member. What happened next was like an express train to deportation, one that barely stopped to pick up due process along the way. Immigration officers began rounding up Venezuelan men accused of ties to Tren de Aragua. Many of these individuals were asylum seekers or just people who had fled Venezuela's chaos, hoping for safety in the US. Now, suddenly they were labeled alien enemies. According to court filings, more than 130 Venezuelan men were swiftly put on planes and flown to a prison in El Salvador. Yes, not even back to Venezuela, but a third country's mega prison, without so much as a hearing. Some of them got as little as 12 hours notice before being shipped off. 12 hours, y'all? That is less time than Amazon's next day delivery. And these folks were expected to somehow mount a legal defense or even say goodbye to their friends and families in that window, 12 hours. The deportation was that extreme, folks, truly. And you can really read up on all of these stories. And you can see time and time again how many people over the last month, 2 months have been basically shipped out with not as much as a goodbye to give their family members or even some sort of legal recourse. Cue the lawyers and the acronyms. Enter the case of WMM v. Trump. Now, for your understanding here, WMM is one of the affected immigrants going by initials to protect his identity, as many have done in these cases for very valid reasons here in the United States. And he became a lead plaintiff in a lawsuit filed in Texas. Now, his story echoes many others that we've heard before. He says he fled Venezuela seeking refuge, only to be detained in the US and told he'd be expelled under a 1798 law to a prison far away. Along with others, WMM is arguing that this use of the Alien Enemies Act is unlawful, that Trump overstepped his authority by using a wartime power in peacetime, and trampled on their Fifth Amendment due process rights by trying to whisk them away without a fair hearing. In non-legal terms, their message is, hey, you can't just pull out an ancient war law and skip the whole justice thing. This is not the Wild West, okay? Or the 1790s. People have rights in this day and age. WMM v. Trump is actually one of several such lawsuits popping up like whack-a-mole across this country. Initially, a group of lawyers coming from the ACLU and other very well-known organizations, they tried a big class action suit in DC to block all these deportations at once. Enter the Supreme Court. You know how we feel about the Supreme Court. The modern day Supreme Court, to be clear. You know, the Supreme Court, however, they tossed out that entire case, that class action suit, on a technicality. Basically saying, no, you gotta file individual cases where each person is being held. So we can't aggregate them all. We need you to do all of the work for each and every one of these individuals, which only increases the work burden and the difficulty in finding very specific information for one-off individuals instead of a community of individuals. So immigrant advocates fanned out and filed cases in New York, Texas, Colorado, Pennsylvania, you name it. It was happening. WMM's case in Texas and another by detainees in New York were among the first cases put out. And guess what? The courts are not on the same page here. Are we surprised? Truly, no, we're not. In fact, they're split. Kind of like how people argue whether, my God, guys. It's like the bad argument of whether pineapple belongs on a pizza, which, let's be clear, pineapple does not belong on a pizza. Okay? Get that out of here. I want my pepperoni, and I don't need no pineapple. I don't need no sweet nothing on my pizza. Now I'm going to start getting hungry, and I'm sorry if I just made you guys hungry, but that was a random tangent. Anyway, back to the case here. In New York, Colorado, Texas, another case in Texas, and elsewhere, judges initially blocked Trump's use of the AEA, saying it was likely improper to use this law to bypass normal immigration proceedings, which, wow, okay, yes, we're on the same page. This makes sense. These judges essentially said, wait, wartime law in peacetime? Not so fast. No, we can't do that. One federal judge in Texas, not the one handling WMM's case, but the other case, ruled that Trump's invocation of the AEA was unlawful on May 1st of 2025. But on the other hand, in Pennsylvania, Judge Stephanie Haynes, she took a different view in a case involving another Venezuelan man identified as ASR. In a ruling that made headlines, she allowed the use of the Alien Enemies Act, marking the first time a court said okay to what Trump's rhetoric and interpretation of this 1798 law was. However, folks, even Judge Haynes seemed uneasy about how the government was doing things. She scolded the administration for deporting people within a matter of hours of labeling them as enemies. Her order told the feds, give at least 21 days notice and a chance to challenge the removal in court so you don't accidentally deport the wrong guy in the rush. And we've seen headlines of people wrongfully deported that did absolutely nothing wrong. Imagine that. A judge effectively saying, if you're gonna dust off this old cannon, at least aim before you fire. I wish, you know what? Never mind. The judge also insisted that those notices be in Spanish and English with interpreters, so people actually understand what's happening to them. Not exactly a ringing endorsement of the process, even as she upheld the law's use. At least she was trying in some way to provide access and equity. It wasn't a good job, but she at least tried to do something. Meanwhile, the Supreme Court has been peeking in from the sidelines. In early April, the Supreme Court narrowly allowed the deportations to resume, 5-4, by lifting a block from a DC judge, but emphasized it wasn't deciding the ultimate legality yet. Essentially, the Supreme Court of the United States said, file your cases in the right courts, and we'll see. So now, WMM v. Trump and its sister cases are the battleground for a very important precedent-setting question. Can the president enact an 18th century wartime law in order to do the runaround against modern immigration law? The stakes are sky high, not just for these Venezuelan migrants, to be clear, but for the balance of power and immigrant rights in America going forward. Out in the community, while the lawyers are dueling it out in court, the human toll is being felt far beyond the courtroom. Immigrant communities and activists have mobilized in response to this case, and they're bringing both heart and heat to the fight. In late April, relatives of Venezuelan migrants deported under the Alien Enemies Act protested outside the United Nations office in Caracas, Venezuela. They held posters with the names and photos of loved ones who were abruptly sent to prison in El Salvador. These families are demanding justice and information, highlighting the human cost of this policy. In Venezuela, families of those deported have been protesting outside the United Nations office nonstop, honestly, ever since this really came to a head. If you were to search and just look up more information on this story through pictures, you would find pictures of crowds of distraught relatives holding up signs with their loved ones' names, holding up signs with photos of their sons, brothers, sisters, husbands, chanting for justice. Imagine if you were in their shoes. How would you feel? These are people who thought their loved ones had found a haven in the United States, only to discover they'd been whisked away to a foreign mega prison without so much as a phone call. The anguish here is real and it is palpable. One father in a protest held a poster with his son's name and bright handprints on it, pleading for freedom. It's both heart-wrenching and a powerful image of resilience. Families refusing to let their loved ones disappear without a fight. In the United States, immigrant rights advocates are equally fired up. Organizations like the ACLU wasted zero time in filing emergency lawsuits to halt these alien enemy expulsions. Lee Gelernt, a lead ACLU attorney on these cases, has been particularly loud in shouting from the rooftops that Trump's move is an unprecedented abuse of power, a wartime law twisted for a peacetime mass deportation scheme, which I hear zero lies told. We strongly disagree with the court's decision to allow the government to continue using this wartime authority during peacetime. Gelernt said after that Pennsylvania ruling we talked about, vowing to appeal. Advocates point out the obvious dangers. If the president can unilaterally decide a group of immigrants are enemies and strip them of their rights, who's next? It sets a chilling precedent. Today, it's Venezuelan asylum seekers. Tomorrow, it could be any other group falling out of favor with this administration. Immigrant communities across the country, especially Venezuelan American and Latinx groups, have organized rallies, vigils, and social media campaigns to raise awareness. They're sharing stories of the affected families and drawing parallels to those dark historical episodes we mentioned. The refrain, "Never again," is circulating, a direct reference to the Japanese internment and the vow that such injustices must not be repeated. Even Human Rights Watch has jumped in, issuing a scathing report calling the 1798 Act a dangerous instrument, incompatible with human rights, and urging Congress to repeal it. In that report, the HRW highlights that at least 137 Venezuelans had already been sent to El Salvador's huge prison under horrifying conditions, held indefinitely and incommunicado, at risk of torture or abuse. They warn that the US government has a list of 200 plus more names it could still deport under this scheme. And that is the most appropriate thing to call it, a scheme. Those numbers, folks, aren't just stats. They represent real people with families, dreams, and now horrible nightmares of being labeled the enemy. The broader immigrant rights movement sees WMM v. Trump as more than just one case. It's a line in the sand. It's bringing together an unlikely coalition from lawyers in suits to protesters with hand-painted signs, all saying the same thing. We can't let fear and old laws justify new wrongs. There's a mix of fear and determination in the air. Fear, because if the courts ultimately side with Trump's use of the Alien Enemies Act, it could open the door to a much more aggressive and unchecked deportation machine. Advocates are determined to see the AEA repealed and dismantled. They see it as an opportunity to slam that door shut and maybe even exorcise this 18th century ghost from our legal system once and for all. So, here we are. Precedent pending indeed. A precedent from 1798 is pending right now on the outcome of WMM v. Trump and related cases. It's a clash between an ancient statute and modern constitutional values. It's also a clash between a hardline policy and the very real lives it upends. In our time covering legal battles, few has felt as surreal as this one. There's a bit of dark humor, if you will, in the absurdity. An immigration case where John Adams is effectively a supporting character. Oof, if only he knew his law was making a comeback on podcasts in 2025, child. He might have added a sunset clause. But there's nothing funny about what's at stake for the people involved, okay? For families praying with their dads and sons to come home, for communities wondering if they're safe, this fight is deeply personal. The Alien Enemies Act may be a relic, but this battle is a very present and very urgent one. It forces us to ask ourselves, how far can we let fear push our laws? And will we allow history's mistakes to repeat under the guise of security? As we wrap up this segment, our hearts are with those caught in the crossfire of this case. The parents holding protest signs, the lawyers working tirelessly day and night on habeas petitions, and the immigrants sitting in detention, hoping that America's promise of justice isn't just a cruel joke. Keep your eyes on this one, folks. WMM v. Trump is more than a legal tussle. It is honestly a test of our values. We're watching a precedent in the making or unmaking. And whatever happens, you can bet we'll be here to break it down with however I can interject some sort of humor, but there will definitely be a heaping helping of heart and a magnanimous hope that the arc of the legal universe bends towards justice. Until next time, stay informed, stay compassionate, and stay aware of your rights. History is watching, and so are we. Actually, hold on. I'm not done yet. No, I'm not done. It just hit me. Let's keep it 100, okay? When we're using a law written before Black folks were even considered citizens to deport immigrants in 2025, that's not just wild, it is increasingly dangerous. WMM v. Trump is more than some obscure case number. If you haven't been able to pick up on that at this point, y'all, it's a flashing red light on how quickly rights can be stripped when power goes unchecked and people have their own motives and want to prey on others' insecurities and fears. If this case sets the wrong precedent, it won't stop with Venezuelans, y'all. It'll open the door for every tired, dusty, xenophobic fantasy to become federal policy. And I don't know about you, but I'm not here for turning back the clock on humanity, especially because someone's clinging to colonial energy in their quest to establish authoritarian rhetoric, rules, and society. Get the out of here with that. This case matters, y'all, and we'll be watching, because when the precedent is still pending, our voices need to be loud. Our voices need to be heard. They need to be persistent. Our eyes need to be open, and our values, they must remain non-negotiable. Let's take a quick break, because that was a lot. And we're going to come back and lift up the mood a little bit with Cite Me, Don't Fight Me. Ooh, y'all. Ooh, y'all. After that legal deep dive, we just need to come up for air collectively. Okay, let's come up for air. Let's come up for absurdity. Because now it is time for Cite Me, Don't Fight Me. The segment where we trade Supreme Court drama for small town nonsense and big, who asked for this law kind of energy. These are real statutes sitting in dusty code books across America. And listen, I couldn't make this stuff up if I tried. I really, really couldn't. So whether you're into bears, chicken curfews, or sandwich shop serenity, you're in the right place. Let's get weird. Our first story takes us over to Alaska, which they've been a repeat offender here in this category over a couple of episodes. But I want to say first, I want to preface this law and say, if you're out in Alaska, just enjoying Alaska, and you see a bear asleep, and your first thought is not, oh, let me get out of their way or let me avoid interaction, but it is, ooh, let me see if I can get a photo of this up close for the gram. You're a part of the problem, clearly, and you deserve what happens next. Believe it or not, in Alaska, there is a law that you do not need to wake a sleeping bear for a photo. Now, I feel very strongly that this is common sense. However, believe it or not, Alaska had to make it illegal to wake a sleeping bear just to take a picture, because apparently common sense was not common enough. This law is part of Alaska's broader wildlife protection rules, which I love that. But its specificity is very telling, and it's telling on someone. Someone definitely tried to treat a grizzly like a museum exhibit, and the state said, not today. Insert random white person name, because I can guarantee you it was not someone black. I'm just saying, IJS, don't come for me. I'm just giving you, I'm giving you facts here. And I can say for damn sure it was not a black person. If you think it was a black person, I want you to say in the comments that you think the person that actually did this, that caused this law to be even made in the first place, was black. And if it is a black person, you will get an Overruled t-shirt on me, okay? Now, this is why, having all of this context added here, this is why we need laws and boundaries. because people will look at a 600-pound apex predator and they will look and say, how cute. Oh my God, let me get close and take a pic. I love bears, they're so cuddly. They are not cuddly. They will kill you in one swipe, okay? So Alaska, you did your good one on this one. And to those who would even think of running up on a bear, let this be your very, very clear warning not to do that. Okay, let's go on down, let me say, to Little Rock, Arkansas, where our second law comes to play. There is a law, no honking near a sandwich shop, okay, after 9 p.m.
Excuse me?
Yeah, it's the law you never knew you needed. The law that is like, I can find some sort of random, use for that. This is all me being facetious, okay? And listen, I'm all for preserving peace, okay? But Little Rock said, leave that pastrami on rye in peace or pay the price with a fine. According to city ordinance, it is illegal to honk your car horn near a sandwich shop after 9 p.m. Yes, sandwiches have a bedtime, and apparently they're light sleepers, so keep it quiet. Now, I don't know what beef someone had. Oh man, come on. That was your dad joke today. Come on, you needed it. It was funny. It's punny. We love dad jokes and punny humor here. Okay, I'll start back. Now, I don't know what beef someone had, pun intended, that made this necessary. But I'd bet money that someone was honking at their partner who went inside to grab the food. They were taking too long and they laid on that horn and everyone was pissed about it. And the city said, you know what? I got something for that. Now, ask yourself, guys. Ask yourself. Is this protecting local tranquility? Or is this a deli discrimination situation? Either way, if you're in Little Rock after hours, keep your horn and that hoagie humble. Our last law we'll cover takes us to Quitman, Georgia, okay? Shout out to any listeners that have family or are from there. This law is truly chef's kiss of shenanigans and tomfoolery. I can't. Okay, so let me tell y'all. Okay, so in this third law, you can be fined for letting a chicken cross the road. And I say that and I mean it. Like, this is truly on the books. What's crazy is that this law plays on a very common joke that all of us have heard before. Why did the chicken cross the road? Okay. In Quitman, it is categorically illegal to let your chicken cross the road. Why? Who knows? But apparently the age-old joke finally got legislative consequences. So I have some follow-up questions that I would love to ask, but I know they will never be answered. Like, what if the chicken had a permit to cross? Do they need to be permitted? What if it was good question here. What if it's a free-range chicken, right? They walk everywhere. They can just go wherever. So that includes roads. So free-range chickens couldn't cross the road? I'm just saying, let's use some logic for this very illogical law. This law basically says, we see your comedy and we raise you a citation, which means technically in Quitman, why did the chicken cross the road? Well, because its owner didn't read the city code and now owes $75.
Yeah, Double homicide.
I gotta say, this was probably one of the most outlandish laws. I mean, there have been several many that I've given y'all over these episodes, but this one is absolutely kookarach. Why in the world are we worried about whether a chicken can or cannot cross a road? Can we work on understanding why we landed here in the first place? No, we don't have time for that. Anyway, so whether it's waking bears, disrespecting sandwich curfews, or outlawing punchlines, the law is nothing if not, let's just say, creative. Yeah, creative. And remember, before you act out, ask yourself, is this a felony, a misdemeanor, or just really weird and super enforceable in Arkansas? Either way, cite me. Don't fight me, y'all. Let's take a quick break and we'll round out the show with our last segment, Objection, Your Honor. All right, we're back. Now, listen to my heart, you know? Well, you have no choice because you're here listening to me and I am talking at you. Not really to you, but at you know what, whatever. So I'm just gonna jump in because, baby, this week I had like an amalgamation of so many different things that I wanted to bring up, but due to maybe very, very, very low grade like ADHD or something like that, my mind couldn't really focus on one or the other. And it started to stress me out. So I was like, you know what? I'm just going to go with the first thing that comes to mind here, okay? So listen, here we are. Let me put on my dramatic reading voice. No, I'm not doing that. It's crazy. All right. So here we go. You ever try to be calm? Like, really try. Keep your head down, stay composed, let stuff slide until suddenly you're staring into space like, nah, I'm not built for this. I'm not built for this foolishness. Welcome, friends, to Objection, Your Honor, where my last straw has officially been filed as Exhibit A. This is the moment of the show where I stop smiling through the nonsense and start saying what needs to be said out loud, on purpose, and without apology. Because sometimes silence feels like complicity. And baby, I am not the one. Today's objection, the false scarcity behind the phrase, there's only so much room at the table. I don't know who needs to hear this. Actually, scratch that. I know exactly who needs to hear this. But the table in question, it's not full. It's not fragile. And it damn sure wasn't built to only seat the same 6 folks who all look, think, and move the same way. This idea that making room for more voices means someone else has to be pushed out, it's a lie. It's the lie that keeps marginalized folks on the outskirts. It's the lie that tells us we have to wait our turn, tone it down, or just be grateful to be in the room in the first place. But let me be crystal clear. We were never meant to sit quietly in the corners of someone else's comfort. See, they love to say diversity like it's a buzzword, but not when it's inconvenient. Not when the room gets a little louder, a little queerer, a little blacker, a little less easy to ignore. Suddenly, room's too small. Suddenly, there's no budget. Suddenly, we already have someone filling that slot. But thank you. That slot you mentioned. What, being that one voice of reason? That slot? The one person asked to represent every single layer of their identity in every meeting? every panel, every policy draft? Nah, I object. The table is big enough. Hell, if not, build a longer one. Add a folding leaf. Drag over a chair from the break room. We have the tools. We have the people. And we have the right to belong without being tokens, without being temporary, and without being asked to shrink just to make others more comfortable. And to be completely real with y'all, some of us aren't just asking for a seat anymore. We're bringing our own damn chairs and tables. Better yet, we're building new tables all together. Tables that are rooted in truth, equity, and power sharing, not power hoarding. So if the sound of new voices makes you uncomfortable, maybe you weren't listening. You were just used to hearing your self-talk. If nothing else, let this episode be your reminder. The table is big enough. It's always been big enough. It's just been guarded like a secret, rationed like a privilege, and built without enough chairs on purpose. But we're done waiting for an invitation. We're done shrinking to fit. We are all walking in, speaking up, and holding space, not just for ourselves, but for the ones who've been silenced, overlooked, or told they were too much for the room. Because representation isn't radical, inclusion isn't optional, and power, it's better when it's shared. So whether you're already at the table, building your own, or still looking for the door, know that you're not alone. And you're not asking for too much. You're asking for what is overdue. If this episode spoke to you today, I love to hear it. If you laughed, nodded, or had a whole internal say that, you better say that moment, do me a favor. Rate this show 5 stars, leave a review, and send it to your people. Do your big one for me. Come on, my birthday's upcoming. I want you guys to, help me celebrate. Share the pod. Honestly, that's how we grow. That's how we reach the folks who truly need to hear these conversations just as much as we do. Follow us on Instagram, TikTok, and Blue Sky at Overruled Podcast. And subscribe on YouTube at The Overruled Podcast. Have a legal oddity, a rant of your own, or a weird law you want me to roast? I want to hear from you. Email us at theoverruledpodcast@gmail.com. Seriously, drop me a line. And most importantly, be nice. Until next time, stay bold, stay grounded, and keep demanding better. Keep demanding more. Because court, it may be adjourned, but the work still continues. Okay, y'all, bye. Oh, baby. Oh, girl, I gotta tell you, if y'all only knew how many takes I had to do on this particular episode, it's wild. You know that feeling where everything is like you have it prepared. You're ready to go, this, that, and the other, but it's like your mind is like it's not catching up with you. So I have so many outtakes from this episode. This is wild. So yeah. I am not looking forward to the editing part of this. I already know what it's gonna be. And I may have to re-record this altogether, girl. But what was I gonna say? And still I rise. How about that? Period. Period. Okay. Period. I gotta get my life together, y'all. I gotta drink some water, I've been drinking water all day, and thankfully I can tell from this The skin's looking good, we're glistening, we're glowing, we're happy, okay? But we're also tired. Um, okay. That's all I got for y'all. That's enough of um Jay behind the scenes for now. I'll talk to y'all later.